Coral Creek. All right, we have two gentlemen. Both sides ready? I believe, Mr. Woods, you're the appellant.
Yes, Your Honor.
All right, would you like some rebuttal time?
5 minutes, please.
You got it.
Greg Woods on behalf of Mike Rollison and the other listed appellants. May it please the court. This is a golf club deposit refund case. At paragraph 67 of the lower court's final judgment, the court stated, plaintiffs have no vested right in redemption. It is not a debt to be paid at a specific time. Rather, they received a contract which by its terms was specifically subject to changes in the plan that might be made from time to time so as to meet the needs of the club.
All right, you started at the core of this case, which is paragraph 67. So that generates a question that's been on my mind. If you were to break vested rights into two segments, vested rights as to the amount, I don't think the parties, and this is a question, I don't think the parties are arguing the amount was determined under the 2009 plan. That's the 85% rule. It's the timing of when that amount is due, how many memberships have to be sold, where you are in the list and so forth. Is that a fair question?
Your Honor, that's not quite right, because under the 2003 plan, as reflected in 2009, the amount of the deposit is determined at the time of resignation. Under the 2018 amendments, the amount that you get is determined at the time your certificate is redeemed. So if the price of the new certificates dropped precipitously or rose greatly, you would be getting a different amount. So not only is the timing been altered, but the amount is also potentially altered.
So,
Okay.
so that explains the generic language in paragraph 61. The judge doesn't distinguish between the timing or the amount or the date the payment is due. He
Correct,
says
yeah.
it's all vested rights. It's a moving target. The club retained the right to change the membership at any time. And even though these folks joined, I think when 2003 plan was a fact, there was a modification indicated that it could be modified, and it was modified in 09 and then 18. Is that correct?
Well, Your Honor, if you will indulge me with a little patience, I want to walk you through the documents themselves.
I don't want to get you off your argument, but you raised that paragraph 67.
I'm going to address that issue and address it at some length, Your Honor.
Okay.
Okay. And basically, the trial court's finding, the holdings in the final judgment are contrary to Florida law. They're contrary to opinions of this court, and they're contrary to the language of the parties' agreement. Under Florida law, a club is not allowed to unilaterally alter the amount of or timing of the payment of the members' deposits. The members have essentially financed the club. They have made a loan, and they are entitled to be repaid. Because this is an action for construction of a contract, we are under de novo review, so obviously the court can look at it fresh. Here, the contract between the appellants and the club was comprised of an admission agreement and the 2003 Coral Creek Club plan. This is acknowledged by the appellees, the club, at page 14 of their brief, where they indicate there is no dispute that the contract between the plaintiffs and the club consisted of the admission agreement they signed and the plan that the admission agreement incorporated by reference. So we're all in agreement as to what the contract documents are. At page 5 of the club's answer brief, they note that each appellant was required to sign the admission agreement, and in order for the admission agreement to become effective, they had to pay deposits. Interesting, even if one looks at the last page of the admission agreement, it's not effective until you pay the deposit and the club has signed the document. So that's the last stage of the contract coming into effect. The club then cites the various provisions in the admission agreement. And paragraph C of the admission agreement states, the applicant hereby acknowledges receipt of a copy of the Coral Creek Plan dated June 1, 2003, parenthetical, the quote plan, quote, and agrees to be bound by its terms and conditions as supplemented by this admission agreement. So the admission agreement is the final stage of the contract. The plan's out there, 2003 plans there. We now sign the admission agreement. It supplements that plan, and it's the final say on the parties' agreement. Note that they have defined the plan in this admission agreement as the June 1, 2003 plan. It's specifically defined. Now, I'm going to, this language in other contexts, in the Feldkamp case and in the Veranda case, which we're going to discuss, the agreements, the initial agreements that the people signed also reference the plans. But in Feldkamp and Veranda, the language used in the agreement said they discussed the plan as it may be amended. So they contemplated potential amendments to the plan in those two agreements. We don't have that here. Here, when my clients signed this document and the club signed the document, they locked into the 2003 plan. And the 2003 plan has the express provisions on how much, the timing of the redemption, the 4-to-1 ratio, the 1-to-1, and the amount of the redemption, which is determined at the time of resignation. The next key provision in the admission agreement is paragraph D. The applicant acknowledges that his or her membership deposit shall be refunded only in accordance with the provisions of the plan. Again, the plan has been defined as the June 1, 2003 plan. So paragraph D, the appellant acknowledges that his or her membership shall be refunded only in accordance with that 2003 plan. So we are locked into the terms of that 2003 plan. Paragraph G of the admission agreement. This admission agreement may not be amended or modified, nor shall any waiver of any provision hereof be effective except by instrument in writing executed by the club and applicant. So
didn't the 2003 plan say it could be amended? So in other words, that provision of the 2003 plan is incorporated into the admission agreement?
The 2003 plan can be amended, Your Honor. It allows amendments of those terms in the plan. And there's lots of terms in the plan that can be amended. There's no ifs, ands, or buts.
So, but you're saying by signing, correct me if I'm not following correctly, you're saying by signing the admission agreement, they were locking themselves into all the benefits of the plan as the 2003 plan. But didn't they also, incorporate by reference into the admission agreement, the provision of the 2003 plan, which said upon the requisite vote, it could be amended?
Yes, Your Honor. You're right. And this is very subtle and it's very hard. They can clearly amend the plan and they can amend the plan by voting. What they can't do is, remember, the admission agreement is the last thing signed. The admission agreement says it supplements the plan. So it is the final part of the parties' agreement. And as I just said, the refund provisions are only in accordance with the provisions of the plan. And so they've and the plan's defined as 2003 in our agreement. And so I can show you, it doesn't really matter. If it had said the plan as amended, you will see the Feldkamp and Veranda cases, my clients still win. I'm just trying to show you that our agreement is even more favorable to my clients because it mandates the 2003 terms of 310 plans as to the refund terms. Now that, other provisions of the plan can be amended. That's all permissible. But this amendment agreement, it only has a few sections and it specifically addresses the refund policy and locks in the refund policy. And that's why the court is totally incorrect. I will show, even if we had if there was more flexible language, if the amendment agreement said.
So let me ask you, so if as to those matters in the plan that are not specifically mentioned in the admission agreement, you would agree that your clients are bound by the amended version. But you're saying because the admission agreement specifically mentions a refund and mentions in the same sentence the plan, which is referenced in a previous provision as the one being in effect in 2003, therefore they're locked in.
That's right, Your Honor. But even if it said the plan as amended, because that's the language used in Feldkamp and Veranda, the law is still the same. The club cannot affect my client's vested rights. When they sign their agreements, when you loan $125,000 to the club and you sign an agreement saying how much you're going to be paid back and the timing of that payback, you are absolutely locked. That is a vested right. And that.
Well, let me just interrupt you because the timing of the agreement seems to me different from the amount. Once you're placed on the redemption list, isn't the amount of the refund necessarily determined when you put on that list? Does that become a vested right? And is that different from when you get right. Payment?
I agree, Your Honor. Once you've resigned, the amount is vested as well. So that, and I don't think the club contests that part.
But the last membership needed to be sold never occurred, so no one ever became vested in getting repaid.
Well, we're going to discuss that as well, Your Honor.
Well, I know you're not happy with the timing. It's all about timing because having a vested right to $1, but you never get paid, it doesn't give you a whole lot of anything, does it?
Correct, Your Honor.
Okay.
Can I pause real quick?
Minutes left.
Oh, sorry. Can I pause real quick and have you?
Time.
Can I pause real quick and have you just again, so I write them down and remind me of which of the two cases you were just mentioning. I think they were the cases in which there were two separate agreements. One, the amended agreement incorporated by reference to the other agreement. What are the two cases you just said?
The Feldkamp case, Your Honor, it's Feldkamp versus Long Bay Partners.
I got it. It's fine. It's in the briefs. And what's the other one?
Okay. And the Veranda case, which was actually issued by this court.
Right. And you're saying there, I mean, I'm sure Mr. Murad, if I'm getting his name correctly, will distinguish those or do his best to distinguish them. But I just wanted to make sure I wrote them down. Sorry for taking your time.
No problem, Your Honor. Thank you. All right. I'm going to discuss the Feldkamp case. It's a federal court opinion. And in the Feldkamp case, the court actually lists the application. It has an application for resident golf membership. And the court lists the terms that are contained in that application. And one of the terms in the application is, that the deposits be refunded within 30 days. But another provision in that in the Feldkamp application is that I hereby acknowledge the receipt of the Shadowwood Country Club membership plan and the rules and regulations and agree to be bound by the terms and conditions thereof as same may be amended from time to time by the club or Long Bay Partners. So in their agreement, they agreed to be bound by the plan as it might be amended. So it's It's looser than our specific agreement. The court then goes on, describes the membership plan. And it also notes that in the membership plan, it provides for the 30-day refund upon resignation. The court notes,
We don't have that in our case. Feldkamp had a specific due date for payment, irregardless. We don't have that.
no, but it wasn't. Veranda is like our case in that regard, Your Honor.
You're down to 5 minutes. Did you want 5 minutes for rebuttal?
Oh, yes, Your Honor.
So you have to stop now, or if you keep going, I'll charge it against your rebuttal time.
No, I'll save it for rebuttal, Your Honor.
You want to save it for rebuttal? Okay. All right. That leaves Mr. Murad for his turn.
Unmute my audio. Okay, there we go.
You're good.
Good afternoon, Your Honors. On behalf of Coral Creek Club, I'd like to explain that the way we see this case, it's actually very straightforward. The contracts are very clear, and the explanation you just heard of them by Mr. Woods was totally wrong. They don't relate.
Before you get to that, in Feldkamp, you distinguish it by saying the document, which I'm analogizing to the admission agreement, did not. The document in that case that I would analogize to the admission agreement in this case did not provide for amendment. But isn't that the same thing as this case? The admission agreement here also did not provide for amendment.
No.
The only thing that talks about being amended is the body of the 2003 and 2009 document.
Correct. The distinction that needs to be made is that there's two documents. One is the admission agreement document. One is the plan document. The admission agreement document in Feldkamp creates the right to a refund within 30 days of resignation in the amount that was deposited.
So the distinction is in Feldkamp, the document that did not provide for future amendments described the circumstances under which the right could be obtained. Whereas here, the incorporated document, which did provide for future amendment, is where the right and the conditions under which it could be obtained is described.
That's correct. The admission agreement in Feldkamp couldn't be amended. It referred to the fact that the plan in Feldkamp could be amended as to the regulations with respect to the use of the property, but it didn't say you can change the right to a redemption. The same thing is true in Veranda. The Veranda document, the application said you're entitled to a refund under certain circumstances, and then there was a separate plan as to which there was the ability to make amendments, but it only controlled things other than the amount of the refund, the timing of the refund, and so forth. Our case, while the application says that the applicant acknowledges that his or her membership deposit shall be refunded only in accordance with the provisions of the plan, and that the club will report the refund of the membership deposit on Form 1099 in accordance with the requirements of the Internal Revenue Service, and that's at R-22353, is saying we here in our application for membership do not say anything about the amount of the deposit. We do not say anything, of the refund or how it's going to be done. That's all taken care of over in the plan. And in fact, if you read the plan, everything relating to the amount of the deposit just left basically to the club, which is the owners of the club, and the amount and the methods, every other kind of method of how things are going to be redeemed is left to being amended by not the club. And this is, I talk about this, and it sounds silly in my brief where I talk about how the club is defined in the plan as CCCDR and CCCOP. CCC DR is the owner of the land. CCCOP is the operator of the property. Those two together are the club. The club can't change the plan. The club can propose a change to the plan. The club has to consent to a change to the plan, but the plan says how amendments to the plan can be made. And it says that at any annual or properly called special meeting of the members of the club, excuse me.
Well, without, I don't think anyone's disputing that the procedures for amending the plan were followed. I think the argument is whether or not the rights were vested prior to the 2018 amendment.
Well,
And so, I mean, I just wanted, before you ask me your question, let me finish mine. Paragraph 67 of the final judgment seems to say there were no vested rights. And my question at the outset was, are we to take that to mean there were no vested rights in the amount? Because once you're on the redemption list, the amount seems to me that was determined to get on the list. The amount's determined, but the methodology and when you get paid could be amended as long as the right to be paid was not vested. So the judge made the blanket statement, there are no vested rights here. And my question is, should we make a distinction between the amount and the timing of the payment?
no.
And tell
And
me
the
why
answer
not.
to that's because the document, the plan document, in the text of the plan document says that the amount that you're going to be redeemed is the amount of the next redemption that allows you to be redeemed. So in other words, if you paid 150,000 and the price at the time that you get redeemed 10, 12, 15 years later is 50,000, it's calculated based on 50,000. If it's 300,000, it's calculated based on 300,000. There is no vested right with respect to the amount or the timing of the redemption.
So you're saying the amount could be higher or lower? Usually it's going to be lower because there's a percentage less than 100% involved, correct?
Actually, in the club business, it's usually higher, but you start getting situations where it can be lower.
Except in this case, there's a membership shortage.
The membership fee, the amount paid by a new member, has stayed basically the same for a long time. The goal in a club is to have the club become so popular that the prices can go up and maybe everybody can do better. But if the club fails, prices of those memberships will go down and people will get less. So nobody has a vested right to anything. And by the way, at trial, there was no serious argument that there was some sort of something fixed like this. Somebody pointed to something in a chart somewhere in a plan that said, see, that says you get this amount.
I don't think they're
based on the
claiming
date
that.
of your redemption. Well,
But there's an opinion,
I
but there's
think
no
they're
evidence of
claiming
that.
that they're vested, that they are vested in the amount and in the redemption rate, 4-to-1, 3-to-1, 2-to-1, 1-to-1, depending on whenever it is. And our position is that Reynolds versus the Surf Club and Feldkamp and Veranda and the other cases, Hamlet, the other case that we cited, make it perfectly clear that because the document that contains the provisions relating to the redemption rate, 4-to-1, 3-to-1, 2-to-1 can all be changed by a vote of the members, which included the plaintiffs in this case. They can all vote. That makes it so that it can't be vested. Hamlet says that it can't be vested if the right to it arises from a document that can be amended by procedures which are followed, and if they're followed correctly, then anything can be changed with respect to those things. The only thing that these people are vested in is when they buy a membership, they're vested in the right to be paid back the amount that they paid 30 years after.
Right, and we don't have that. Nobody's got the 30-year.
We got to wait till 2033 for that one. It's not right. But the point is that all of these things could be amended. They were amended, and they were properly amended. And I know Your Honor indicated that you don't think that the appellants are arguing that they're fixed as to the amount. They are claiming that they're fixed as to the amount, and below they argued that they were fixed, but they never put on the evidence necessary to support that. And what Judge Porter saw at the trial was the evidence that was presented, which was there was an incorporated by reference 2003 plan, which had a statement in it that said, this plan is defined to mean this plan, as it may be amended from time to time, and contained provisions that told how to amend and how that is done, not by the club unilaterally, not like Feldkamp where it's done unilaterally, not by Veranda where it's done unilaterally, but by a proposal being made either by the advisory committee or by the club, and then a vote after notice to everybody. And that's exactly what we had here. And that's why they made the complaint that the vote shouldn't count, or that there was that somebody was misled by this information that was put out by our clients. And in fact, that was all wrong as well. They say that people were misled, but they put on no testimony of any witness who said, I was misled. What Mr. Rollison, who's the lead plaintiff, said, I wasn't misled. No one else came in and said, I was misled. They're basically arguing, well, the other people who voted could have been misled, and so therefore you should invalidate the vote. Well, they have no one who was misled, no one who says that they were misled, and as far as I understand it, nobody has the right to file a lawsuit and claim that they suffered damages because somebody else might have been misled. That's not the way it works. They have to have a claim. They have no claim. And by the way, Mr. Ellert is not an appellant in this case, just in case you're checking. He wasn't listed in the notice of appeal, and he's not listed in Your Honor's docket indicating who the plaintiffs are, or who the appellants are. So let's see, what else did I need to talk about?
If they could have alleged, if they could have alleged that enough voters were misled and the parties themselves were a little more savvy and weren't misled, could that lead to a claim based on the covenant of good faith and fair dealing if what the club actually did was essentially stymie a performance obligation that would otherwise have been effectuated? I mean, the covenant of good faith and fair dealing says you have to base it on actual breach. The breach would be, hey, under the 2009 plan, your obligation is to pay me X, and you used the defrauding of a majority of the voters to actually change the performance obligation. In other words, well, you say, well, we didn't breach the performance obligation; it's changed. And they say, well, you have a covenant of good faith and fair dealing to not fraudulently change the performance obligation. I'm just saying, isn't that their theory? And what did you say?
I've never really understood exactly what their theory was. I've done everything I can to defend every theory I thought that they had, but I don't think that they have one that relates to a breach of the obligation of good faith and fair dealing, because while it must be tied to a breach of a contract provision, it has to be a contract provision where somebody has some sort of leeway in terms of how they perform it. And the description that you just gave of defrauded voters would be a different claim. It would be a class action claim or a mass action claim that all these people were defrauded, and then they would put on some proof that there were fraudulent statements made, they were material, people got misled by them, they relied to their detriment, they would have done something differently, and then we could maybe get a mandatory injunction or another injunction that would relieve them of this problem. But none of that happened. What we had was, and I'm going to go back to the beginning. The beginning, this was a declaratory judgment action, essentially by Mr. Rollison, essentially demanding that he get all the financial information of the club and all the financial information of all the owners of the club and everything about it none of which had anything to do with any of the claims that ultimately got tried. The claims that ultimately got tried were claims of whether the thing was properly amended. We say it was. Whether they were harmed by the failure of the club to base dues on a 10% maximum management fee, or maintain a reserve allowance for repairs, or various different things that they said you didn't do these things under the plan. But every plaintiff, except Mr. Ellert, resigned under the 2009 plan because they had become members before 2009 and elected to not pay any more dues and not use the club anymore. So if the dues were too high, it didn't make any difference to them. If the property wasn't maintained, it did not make any difference to them. If the club owners, investors were taking out too much money, it didn't make any difference to them. It could have, if they had hired a qualified expert to predict how many members would have been sold, memberships would have been sold, if all these other things had been fixed in this other particular way, and therefore, but the testimony at this trial was, everybody agreed, you can't predict when a membership will be sold or what the price would be for which it would be sold, and they never proved that there were that the threshold had been met. The standard in this case for them to get this thing overturned is they have to show that there is some material provision of the judgment that for which there was no competent evidence. They didn't even try to do that in the initial brief or the reply brief. All they did in all their briefs was try to re-argue the persuasiveness of the evidence that they did put in, and not just limiting themselves to what they put in at trial, but going back and citing to things like affidavits filed in connection with motion for summary judgment to try and get a change in a ruling relating to the trial itself. We don't think that they've done what they've had to do. They make complaints about discovery. I had a whole litany of things to talk about discovery. They got no complaint about discovery.
You got about 3 minutes left, so use your time wisely.
I will. I'll make it. They sent us discovery requests. We moved for protective order. We had a hearing. There was a ruling. We responsibly responded to the discovery. They never moved to compel better answers to the document requests, to the interrogatory answers. Yet now they're claiming that we had an obligation to have done more in terms of that. They tried to get an extension of time for discovery, asking for like the last 14 days before the trial was supposed to be started. They did not put on an appropriate case for that. They had demonstrated over the last 18 months before that they weren't going to get it done no matter what. And so we went to trial. We put on the evidence that we had. The judge decided the motions for rehearing and for for continuance relating to discovery in her discretion, which should not be disturbed by this court, because the evidence that was presented to her at the hearings was insufficient to allow that to happen.
All right, thank you. Mr. Woods, you've asked for 5 minutes, and that's what I've given you.
Thank you, Your Honor. I want to start with reading an excerpt from the Feldkamp case. Because the Feldkamps agreed to be bound by the membership plan and rules and regulations, which may be amended from time to time by the club or LBP. LBP argues that any promises made in the application were also amendable. Accordingly, LBP asserts plaintiffs had no vested contractual rights. Looking at the contract as a whole, the court finds LBP's interpretation is unreasonable. Feldkamp's right to refund of their deposit became vested upon their admission to the club, which is exactly the same thing we have here. My client's rights to the club, to the 85% time of resignation is set forth in the 2003 plan, which vested when they signed on. And the timing, the 4-for-1 and then 1-to-1, we got 225 members, was also set at that time. The Veranda case, the issue before the court was when the club decided to change the club from 1 in, 1 out, which affects the timing of redemption, to 3 in to 1 out. The court held that that was a material that violated the members' vested rights. Here, the 2018 amendments do the same thing. They extend the cap. The cap goes from 225 to 275. They change the terms of how many redemptions are needed, which prolongs when my clients will be redeemed. As Veranda found, that's not appropriate. It affects their substantive vested.
What in the admission agreement are the plaintiffs relying on to describe their entitlement to a certain amount?
Okay. The admission agreement, Your Honor, incorporates the 2003 plan very specifically.
So the 2003 plan is where the benefit or the right is described.
The 2003 plan.
That is an amendable document by its own terms.
It is until the final document, the supplement to the parties' agreement, says that the rights to a refund are locked per that agreement. And that's at paragraph paragraph D. The applicant acknowledged that his or her membership deposit shall be refunded only in accordance with the provisions of the plan, which is defined as the June 1, 2003 plan. Only as a plan. And that plan had specific instructions. It had the 85% upon resignation, and it had the 4-to-1, 1-to-1 ratio set on time.
Feldkamp was not decided based, did not hinge on the fact that the actual description of the benefit appeared in the non-amendable document that incorporated reference to plan.
The same benefit appeared in the plan. The exact same term that was in the agreement also appeared in the plan, which was amendable. So the defendants in Feldkamp made the exact same arguments as defendants here, and the court went against them. And this court in Veranda adopts Feldkamp. I mean, wholly adopts Feldkamp. And this court in the first Florida bank case, which is also cited in the briefs, discusses the fact that when you have a vested contractual right, despite the fact that the documents provide for amendment, the established vested contract right withstands the ability to amend. Otherwise, what you have is an illusory agreement. Under the defendant's scenario, we can change how much we pay. So they could take this to the nth degree. They don't have to pay us anything.
Mr. Woods, you're down to a half a minute. I didn't want to go.
It would make this contract illusory. They will pay us what they want to pay us when they want to pay us. And that makes it illusory because according to your analysis, Judge, they can amend it to say we only get 43% or 10%. And they can amend the timing so that we never get paid. So that makes the contract illusory.
All right. I don't want to let you keep going without telling that you are technically out of time. I want to thank you both.
I'm good, Your Honor. I apologize for running over.
That's okay. No. And thank you, gentlemen. Well done. Well argued. We're signing off now. That concludes the docket.